under the new constitution, a legal framework governing industrial relations, and a call to encourage, promote, and facilitate alternative dispute resolution mechanisms, which is grounded in Article 159 of our Constitution. The Industrial Court got a shot in the arm through the enactment of Article 162(2)(a), which established this court as a court of equal status with the High Court. The Constitution of Kenya was very progressive in that it had taken forward-looking positions which mirrored the labor laws in place. The Constitution allowed creation of two specialized courts, which is one to deal with employment and the one to deal with land and the environment. A specialized court is by design created to meet and address the needs of specific constituencies. In our case, it's employment, and it addresses unique jurisdictional issues. And this court has procedures tailored to their needs and a cadre of judges with relevant expertise. In Kenya, we are lucky, we have 21 judges, 21, not enough, but at least better than where Uganda is with only 2. I pray that Honorable Waziri, you will take, Honorable Minister, you will take that to His Excellency the President, so that you can expand the labor court, so that you can encourage the creation of various systems to allow for speedy resolution of disputes. Specialization is rapidly gaining momentum across the world, and that is attributed to the demand for access to justice for higher quality decisions by experts in respective fields. The introduction of our court has led to better decisions and has led to tangible results in efficiency through hearing procedures on the wings of well-trained staff and judges serving in the court. We have also had further reduction of case backlog by diverting cases from the General Court through the reference of employment disputes to the Industrial Court. The general uniformity of decisions also has created jurisprudence to the extent that occasionally my brother and sister from Uganda will pick some decisions from Kenya to apply in various principles, the same way we pick from the two of them to apply to Kenya. In the East African region, courts are being encouraged to apply alternative dispute resolution mechanisms, which is often called the appropriate dispute resolution mechanism, but I heard today the Chief Justice of Uganda calls it African Dispute Resolution, ADR. That is the way to go, because ADR is supposed to be the main means of dispute resolution, as Article 33 of the UN Charter outlines various conflict management mechanisms that parties can adopt for dispute resolution purposes. It provides the parties to a dispute shall seek a solution by either inquiry, negotiation, mediation, conciliation, arbitration, and last in the list, judicial settlement, among other peaceful means of conflict resolution. Apart from promoting workplace harmony and long-term stability, effective dispute management procedures promote the right to access justice and fairness. So the starting point is that contracts of employment provide for means in which resolutions can be achieved. And then we have various conflict resolution mechanisms at the workplace. In Kenya, Section 47(2) of the Employment Act, which mirrors Sections 12 and 13 of the Employment Act of Uganda, provides that a labor officer presented with a claim shall afford every party with an opportunity to state their case and then recommend to the parties what, in his opinion or her opinion, is the best means of settling the dispute. It is all agreed that negotiation, mediation, conciliation, arbitration offer the best in terms of structured processes for resolution of disputes. So I'll go into the discussions in relation to the first avenue, which is negotiation. The negotiation starts with parties talking about the grievance and complaints, and then gradually follow the discussions on how they can achieve a solution. It is important that we note preparation is key, and that includes studying the situation, conceptualizing the consequences, and then setting the rules of engagement. Balance is needed when you are negotiating, and as such, when you fail to consider the interests of the other party involved, you fail. When negotiations are conducted in an atmosphere of trust and confidence, there is a higher chance for settlement. There are advantages in negotiation, which is that the labor conflict is resolved cheaply, fast, and avoids business losses because of the organized work processes. There is minimal disruption, and that is because parties are in control of their negotiation. Negotiations can cause standoffs when parties take hardline stance. Sometimes parties are left unprotected because of the risk of information leaks or non-compliance with their agreements. The other disadvantage is that not all the universally used means of resolving disputes, though being flexible and efficient, it is not often used, and that is because there are power dynamics as well as the inability of parties to compromise, which negatively affects negotiation. The second is mediation. Mediation is gathering momentum as a form of dispute resolution. As you may be aware, in Kenya we just concluded the second mediation summit. Mediation is taking a focal point, and it requires the participation of an impartial person who encourages the disputants to reach an agreement. The mediator helps the parties to determine and agree on the issues and establishes how they might be able to reach a mutually beneficial decision. The mediator is merely a catalytic agent and comes between the parties who are conflicting with the sole aim of helping them to reach a compromise. A mediator must be acceptable to both parties, and other than achieving a peaceful settlement, mediator should have no other interest in the dispute. It is kicked off with the initiation stage where the parties are both informed about the mission, the rules of the game, as well as the need to maintain confidentiality. And then finally, the parties are allowed to engage and then ultimately get to a position where they are at a settlement. If they disagree, that is not the end. There is an avenue through which parties can approach a court and continue with the effort to have their case resolved. In Kenya, we've had, in addition to these wonderful methods of determination, what we are calling court-annexed mediation. And court-annexed mediation is a form of appropriate dispute resolution, which is done under the supervision of the court. Through the social transformation, through access to justice, which is the agenda of the Chief Justice of Kenya, we've been able to reduce backlog because we have parties referred by the court once we screen cases and determine that this matter does not need to have a judgment delivered and that parties can compromise the matter. We refer them to adjudication by a court mediator who is paid by the court and not by the parties. We are able, as judges, to encourage parties to go to mediation, and once we refer a matter to mediation, the mediator has 60 days within which to come up with a finding. If parties disagree, the matter is brought back to court, and then we deal with it in the ordinary course. In relation to Uganda, I don't think you've established the court-annexed mediation. It's something we would encourage the court to do, because I have heard you have 146 districts which require a lot of support. And the only way you can resolve disputes at that level is through a next mediation, where you have a mediator, someone from the ministry, dealing with the parties at the ground on the district level and having a resolution of a dispute so that it doesn't have to escalate to the court. The judge, in our case, is the one who appoints a mediator. We normally don't name them, we just say this matter is referred to mediation. The registrar will be able to check on the list of mediators who are available and forward the file. We set deadlines. We say within the following 30 days, there should be a preliminary report, and within 60 days, there must be a final report, and then we wait for the feedback to come. Once that is done, we're able to resolve disputes. The only disadvantage we see is where parties question the selection of the mediator. Since we appoint the mediator by directing the parties to a court-appointed mediator, parties may think that it is the court making the determination, since they think we may have an issue of conflict as being the appointing authority. But so far it's been working, and therefore we would encourage that, which will reduce backlog, reduce litigation costs, and accelerate the disposition of cases in the court. The next is conciliation, which is pivotal in settling conflict to return to equilibrium. In Kenya, the conciliation is through the ministry, and a conciliator is normally appointed by the Minister for Labour upon a reporting of a trade dispute. Ordinarily, the dispute will have to be determined by the conciliator within 90 days, that's 3 months. And if no resolution is achieved in the conciliation period, the matter is referred to court. When there is partial agreement, the conciliator will refer to the balance of the issues that resolved to the court, and we will determine the balance of the issue that remains. The final one is arbitration. And arbitration is a mechanism where parties are referred to a third-party arbitrator who is impartial to both parties and who provides a binding decision after listening to the parties' arguments and evidence. In arbitration, the disputing parties are not involved in negotiation and mediation. Decision-making is transferred to the arbitrator, who is sort of a private judge, and therefore the parties are the ones who will pick the arbitrator, maybe through the Arbitration Institute. I know we have a chartered institute of arbitrators in Uganda. The chapter would nominate an arbitrator who will hear the matter, who will examine the evidence, and might be someone who is specialized in an area of practice such as construction. It could be an accountant, and then finally an agreement is reached and it is brought to court for adoption. The disadvantages of arbitration is that there might be substantial amounts that is to be spent on the arbitrators, as well as needing to engage advocates due to the complexities in the matters of arbitration. Sometimes arbitration may be less transparent than litigation. At times, when you consider the arbitration award, parties are at a disadvantage. In the final stage, I will look at the critical role of the judicial systems in labor disputes. As you're aware, the courts adjudicate on labor disputes, and the industrial courts have unique jurisdiction to address issues relating to employment and labor relations, such as protecting the rights of employees. And you had the Honorable Minister speak of ensuring the harmony is maintained. Once the matter comes to court, sometimes it is difficult to maintain the harmony, since our decisions are either one We have delivered fair and accurate outcomes in labor situations by applying the principles of fairness and justice, as well as the inherent constitutional safeguards which underpin labor disputes. As you heard from the Minister, the Constitution makes various protections available to workers who are the key wheel in the economy and the future of this beloved nation of Uganda. Once parties are concluded, once we conclude cases in our courts, parties have a right to appeal, and subsequently the appellate court may be able to give a determination different from that of the trial court. The good thing is that in Kenya we have now an opportunity to have judges of the employment court ascending to the Court of Appeal. The interview list for Court of Appeal judges came out yesterday. I'm one of the judges from my court who is on the list. There are 6 of us. We are all arguing for about 20 positions, and we hope that some judges from our court ascend to the Court of Appeal. In Uganda, I would pray that you skip the process of waiting for 20 years, 10 years, 15 years, and immediately start considering having judges who have experience in labor matters ascending to the Court of Appeal. There is the emerging trend which has brought some challenges, which is the impact of technology and the gig economy. In the East African region, technology has made a remarkable difference in how people get jobs. And I'm happy we have people who are tech savvy right here. And the rise of platform work has its challenges. Work arrangements in this sphere are typically short-term or limited in duration, sometimes in a freelance or temporary job which is made through online platforms. The concept of traditional employment has been irretrievably altered, and this ongoing development presents economies in the region with a mixed bag of benefits and drawbacks. Digital platforms offer diverse ways of earning through services like cab or ride-hailing services, people running their own business within sectors such as information technology, marketing, and content creation. This new way of work, including remote work arrangements, have liberated people from the constraints of typical job structures. This allows access to income remuneration options with great flexibility regardless of location. While job independence is one benefit of developing in this sector, it mostly comes with little or no security. There are no social safety nets. As you've seen, we have NSSF here. NSSF deals mainly with the structured employment where contributions are made for retirement purposes. In the case of the gig economy, there is no formal structure of employment, and therefore there is no social safety net. There are no provisions made to access other services or advantages such as health insurance and pension. In the globalization that we all have experienced as a result of what happened a few years ago with COVID, we are more globalized and intertwined. There are cross-border work relationships, and as a result, multinational corporations, foreign investors, international institutions are operating between boundaries, which results sometimes in foreign nationals, expatriates, and migrant workers seeking jobs within the various labor markets. For example, such portfolios promote economic development and knowledge transfer. You'll all agree that if I get someone from Uganda coming to Kenya with a specialized knowledge in, say, production, our country and the industries there will benefit immensely because of the knowledge transfer that will take place. However, there are also challenges because we have to deal with work permits. There are sometimes regulations in immigration, cultural gaps, and legal jurisdiction. In the morning I was talking to Judge Wabire, and he mentioned to me a case where an employee came to work in Uganda for a multinational corporation which is both in Kenya and in Uganda. But after he served in that company, he joined another company How do you navigate where a party has refused to follow the laws in your country and has not protected themselves by seeking registration, and then they suffer a loss? So those areas for navigation are some of the things we have to deal with. And in that particular case, the employee, had that employee been registered or initiated the registration process, they would probably would have been able to benefit from the protections here in Uganda. But having not complied with local law, it was one case where they would not benefit. In the same way, we have cases in Kenya where we've had work from various platforms such as Facebook, which are operated by employers who are not in Kenya, but the employees are in Kenya. And when there is conflict, we've had to navigate that space where we deal with international corporations which have no offices in Kenya but have employees. All these complex legal issues require a lot of investigation, a lot of research, so as to be able to come to the right position. The inclusion of cultural diversity, language and communication barriers need to be addressed in order to have an all-embracing workplace relationship. Finally, I'll deal with the issue of the online dispute resolution, which is a new and emerging dispute resolution option. ODR is supported by the internet and technology-powered processes such as AI, and is accessible through digital channels and assists parties in dispute resolution. It surpasses limitations like physical distance and logistics. For ODR platforms, virtual spaces are set up online where parties can undertake negotiations and other procedures such as video conferencing, communication between the parties, and the exchange of documents electronically. There are invariably electronic case management systems, and I'm happy to hear that the Uganda Industrial Court will receive support to digitize, because that will help in a quicker flow of work. I thank the Minister for making that option available, and I thank you for the support to the Industrial Court. Of note is always the data security and privacy issues, but I believe with proper safeguards and firewalls that can be done. So there are recommendations for employers to ensure that in the future or in the way of work that is current, it's important to have proper agreements in place. Seek legal advice. The Uganda Law Society members are always available to help employers draft good contracts to ensure that you keep to the right side of the law. Ensure you have in those contracts safeguards for employee wellness, as well as alternatives for dispute resolution mechanisms, which include the African dispute resolution. In the case for employers, you need to also, for employees, they need to know their rights and their duties. You've heard it said here that there are certain rights that are inherent to an employee, but there must be an understanding of that right. And where employees have a challenge, they should seek legal counsel, because there is an increasing body of advocates who are skilled in employment matters. I met an advocate here this morning who is very, very keen in employment matters, and therefore with that growing list of advocates who are skilled in employment matters, employees can obtain legal counsel and must be encouraged to seek legal advice where there is conflict, so as to mitigate their losses and ensure that they are effective in resolving the labor disputes. Legal counsel enable individuals to fulfill their roles in protecting their interests and enforcing legal obligations, such as employee contracts. In conclusion, the successful resolution of labor issues in East Africa is of enormous importance, because if Uganda succeeds, Kenya succeeds. If Kenya succeeds, Tanzania succeeds. If Tanzania succeeds, Rwanda succeeds, and all the other countries in the East African economic region. As a result of speedy resolution, we are able to enable the region maintain an amiable and productive workforce. The balance between the rights of the employees and the employers can be achieved where the labor market and the investors have confidence. An economy that is free of strife will have greater productivity, which increases tax revenues, which the government needs to run its operations as a result of increased production. So if we take what has been said by the Minister, that His Excellency the President has a focus on ensuring there is a future for Ugandans to have employment, so that there is more productivity, so that businesses can invest, then you can see Uganda will grow and will have a future where the economy will continue to have an increase, since there will be growth in that sector. Countries in the region are experiencing a transition which was brought about by the globalization and the residual effects of COVID-19, which increased remote working arrangements. The employment space is morphing and causing employment relationships that traverse national boundaries to continue. We therefore need to adapt to the new challenges so as to be able to have resolution of the various labor disputes. Thank you, and may God bless the Republic of Uganda, and may God bless the Republic of Kenya and the East African community, which we all are members to. Asanteni.
Thank you so much, Honorable Justice, for that very remark. I saw my dear Minister taking notes of this at every layer, especially when you hit it about both judges. Our number versus the one of Kenya. She noted and she tapped Honorable Esther, and I was like, this is home. Friends, just many of you who are online and those who possibly don't know who Justice Zioki is an alumni of Lewis and the Clark Law School, Oregon, the US, and he holds an LLM in Animal Law Justice, and still he has served as the judge of the Employment and Labor Relations Court of Kenya. His legal career includes the significant roles such as an attorney and investigator at the Kenyan Anti-Corruption Commission and its successor, the Ethics and Anti-Corruption Commission. He was also a prosecutor